Thank you, Senator Graham. Before I begin my questions, I want to remind my colleagues that following this open session, we'll have a closed session in SVC 217 at 12 p.m. today where you can pose questions that may not be able to be answered in open session. I'd like to start with questioning by just noting the following. I listened to how this program was described by our witnesses. Mr. Fanzone described it as an elegant program. Mr. Barnes described it as agile and specific. Mr. Cohen referred to precision. Mr. Olson that it was irreplaceable and invaluable, and so forth. But since the last reauthorization of Section 702 in 2017, many violations of the constitutional, statutory, and court-imposed restrictions on Section 702 have come to light. Last month, an unsealed Foreign Intelligence Surveillance Court, or FISC, opinion revealed that the FBI conducted improper searches of 702 databases for American communications 278,000 times. 278,000 times. These searches have affected all manner of Americans, such as individuals listed in police and homicide reports, including victims, next of kin, and witnesses to the crime. 133 people were arrested during the 2020 Black Lives Matter protest when, as Justice Department itself concluded, quote, there was no specific factual basis to think the searches would turn up foreign intelligence. And 19,000 donors to congressional campaigns when, quote, the only 8 identifiers used in the query had sufficient ties to foreign influence activities to allow such a search. 8 out of 19,000. Mr. Abate and Mr. Olson, you both testified regarding the remedial measures that have been implemented or are underway, but why should Congress or the American people trust the executive to comply with the law this time in light of this track record?
Thank you, Chair Durbin. I'll first take the question and then pass it off to the Deputy Director. As we both said, the problems that you've cited and that we've identified in our reviews of the FBI queries are not acceptable, and I don't defend them. I'm not here to do that. What I can tell you is that those problems predate the critical remedial measures that were put in place in 2021 and 2022. In particular, the FBI made a simple change to its system at the Attorney General's direction. Instead of, by default, when there was a query conducted by an FBI analyst or agent, searching all of its data, including FISA, raw FISA, and 702 data, it simply switched that to a default opt-in so that from that point forward, starting in 2021, the FBI agent or analyst had to actually affirmatively take the step of saying, I'm going to conduct a search using a U.S. person identifier, and then say why that was reasonably likely to return foreign intelligence information. And it was that single change that has resulted primarily in the reduction of the number of U.S. person queries by 93% from 2021 to 2022. So it wasn't, again, these changes or these problems, these mistakes were not intentional. They were inadvertent. They're not defensible, but they were addressed largely by just simply requiring an affirmative step to search that data because most of those searches were inadvertent. And if I may, one other point on the 278,000 number that's in the court opinion that you cited. Obviously, that's a huge number. The one thing to put that in some context, the one response to put that number in context, that doesn't represent each one of those a single wrongful query. Many of those queries were batch queries. In other words, multiple queries by one mistake, one agent making a mistake. In fact, one of those errors accounts for over 100,000 of the 278,000. So I think it's important to put that number, again, in context, again, not to defend or to excuse that mistake.
It's been a source of frustration since the creation of this program to get adequate accountability for the numbers, either on the positive side or the negative side. And you have to, I hope, understand why some of us are skeptical at this point. That 278,000 doesn't mean 278,000. I'm not sure where you're going with that. Let me just ask the basic fundamental question in the few seconds I have left. Is the skill of our adversaries and the potential destruction that they could bring to us by their malicious acts really made the Fourth Amendment something that we have to question whether we can follow it in the 21st century?
So again, the FBI is committed, the Department of Justice is committed to ensuring the safeguards are followed with regard to 702. There is no diminution of the Fourth Amendment when we're talking about U.S. person queries. In other words, the answer to your question is we do not need to dispense with the Fourth Amendment. The Fourth Amendment applies fully to everything we do. In fact, it's the hallmark of the work that we do when we investigate and prosecute cases is to follow the Fourth Amendment along with the rest of the Constitution. The courts that have looked at this, at FISA 702 and FBI queries, no judge has said that there is a Fourth Amendment requirement for the FBI to query the data that's already lawfully collected. In fact, the courts that have looked at it have said there is no Fourth Amendment violation or requirement. There certainly are privacy implications here, and that's why we've adopted the changes that we've talked about, and that's why the FBI has today announced additional compliance measures, which again are already proving to be effective.
I can't go any further because I've run out of time, but I will tell you that if the reforms that you've mentioned in 2021 and 2022 are the only reforms that you're bringing to this committee as we discuss the future of 702, I've got to see more. I hope there is more that you can present. Senator Graham.